This Honorable Court of Tennessee is now in session. Please be seated.
Thank you, Mr. Clerk. Call the next case, please, sir.
Yes, Your Honor. Vernon Lee Ivey v. State of Tennessee.
Morning, Mr. Stone.
Good morning, Judge. And may it please the court, my name is Wesley Stone. I was appointed by the post-conviction court to represent Mr. Ivey in his petition for post-conviction relief, and that appointment has continued through this court. I do request to reserve 5 minutes for rebuttal, please.
Certainly.
I think in preparation for these arguments, I think that the important thing that I want to stress the most is paragraph 17 of the petition for post-conviction relief. Paragraph 17A provides ineffective assistance of counsel, and paragraph 17B sets forth the grounds upon which Mr. Ivey filed his petition for post-conviction relief. Mr. Ivey entered an open guilty plea based upon misinformation provided to him by his trial counsel. And I will go through each one of these provisions in paragraph 17B. The essence of the advice that Mr. Ivey received was that he could apply for probation in a situation where probation was statutorily unavailable.
What is that? How is that set out specifically in the record? I mean, what was actually said or misrepresented to him, specifically from the record?
So from the petition, and then Mr. Ivey testified at the post-conviction hearing, and both of those support what is alleged in paragraph 17B of the petition. And initially, Mr. Hurst, trial counsel, came to Mr. Ivey and said the state's offering you 10 years at 35% to serve. They continued their negotiations. Mr. Hurst went and talked to the prosecutor, came back to Mr. Ivey and said that he and the prosecutor believed that he would not be sentenced any less than 10 years nor more than 12 for a total effective sentence, and that sentence in 17737 would be consecutive. There would be a consecutive sentence regarding two other cases, 18329 and 18330. In that conversation, as bore out both in that allegation and Mr. Ivey's testimony, there is a discussion about probation. First, Mr. Ivey was a career offender on the D felonies, which put him at 12 years. So that automatically denied him eligibility for probation. But Mr. Hurst told him he would not get more than 12 years if, after making his probation argument at an open sentencing hearing, that it went bad. If it goes bad, you're not going to get more than 12 years. So Mr. Ivey at that point is thinking his maximum exposure at an open plea based on advice of Mr. Hurst is 18 years. And as the court's aware, he ended up with 30 years just in 17737, and then 6, those two sentences running, I guess, wild. But at any rate, I think it's important, and this is bore out in the transcript, and I think it's important also to tell the court that I do believe that this is one issue. I've identified it in the brief as two, but it's one issue. And the issue is that Mr. Ivey did not receive the effective assistance of counsel because he was provided incorrect information. He was misinformed by his attorney. He relied upon that incorrect information, and that prevented him from knowingly and voluntarily entering this open plea. So going through each one of these sentences in paragraph 17B, Mr. Ivey wrote, and the proof bears out, counsel informed the defendant that the prosecuting attorney was offering a plea deal of 10 years to serve in the Tennessee Department of Corrections at 35% to be ran consecutive to a previous conviction of 6 years. This confirms that there was a conversation between Mr. Ivey and Mr. Hurst regarding settlement. It does invoke a range classification greater than standard range 1 offender, because 35% relates to the multiple offender range 2. And then it also denotes the consecutive sentencing as it relates to either Rule 32 or 4035 115. But that suggests total, both in 17-737 and the 2 cases that Mr. Corbin Payne represented Mr. Ivey on, that he would be facing the maximum sentence of 16 years. What Mr. Ivey was not told was, look, you're facing 3 felonies where you're subject to 12 years on each sentence. 2 with a release eligibility after serving 60% as a career offender, and 1 with a release after serving 45% as a persistent offender. And the court can stack all 3 of these sentences for an effective sentence of 36 years. You should break their arm off, shaking their hand, and take this deal now. The second sentence in 17B. Counsel then told defendant that after speaking with the prosecuting attorney again, that they agreed that the court would not impose a sentence of less than 10 years, but not more than 12 years. Denotes the settlement negotiations. Mr. Hurst is relying on what the prosecuting attorney is telling him, not doing his own research, and that he would, that Mr. Ivey expressed his concerns about what he had been told previously, and that Mr. Ivey was told that he would not receive a total effective sentence in 17-737 of more than 12 years or less than 10.
But am I correct that trial counsel didn't testify
That's correct.
at the post-conviction hearing?
That's correct.
So the post-conviction court, I believe, relied on the plea paperwork
That's correct.
that set out, maybe, I'm not sure how specific, what did the plea paperwork set out with regard to the potential sentences, I guess I'll ask.
And in answering that, not only what does the plea paperwork say, but what is the colloquy like?
Right.
And what did the trial court say in taking the plea as far as potential sentences? I think
Yeah.
both of those things I'd like to hear about.
I could answer that question, I think, with one response. There was no proof about how plea colloquies work under Judge Sexton, Shane Sexton. But the record in this case bears out that Mr. Ivey was alone. It wasn't normally in the line of cases, and that, or line of defendants taking multiple pleas, as Judge Sexton normally did. But the plea paperwork supports a finding on its face that Mr. Ivey was properly advised. I don't disagree with that. All the constitutional rights, all of those things. What the plea paperwork doesn't set out, and I think it's important that the court look at the plea paperwork in cases 18-329 and 18-330. And what you'll find when you look at those is in the plea paperwork, there's no designation as it relates to offender classification in those 2 cases, Corbin Payne's cases. In the 17-737 case, the one that's before the court now, there's also no offender classification. But what the proof bears out, and Corbin Payne testified to, and Mr. Ivey testified to, there was an agreement outside of the plea agreement in 18-329, 18-330 that Mr. Ivey would get 6 years. Likewise, in 17-737, there was no designation of offender classification, but Mr. Ivey is relying on his counsel in this case that he's not going to get more than 12 years and not less than 10. So I know that, and I don't want to get ahead of myself, that's why I reserved 5 minutes for rebuttal. I know that the state has argued that the record is incomplete because there's no plea colloquy.
Well, how can we evaluate this without the plea colloquy to know what the defendant knew or didn't know?
I think it's simple. I think the court can presume that the plea colloquy was done consistent and according to law.
What law supports the fact that we can presume that when we don't have the record?
Because there's a written plea agreement signed by Mr. Ivey, signed by the state of Tennessee, that colloquy, and we've not raised the issue of the there's some deficiency in the plea colloquy.
Well,
But you're raising the fact that he wasn't informed, and usually part of the colloquy goes through, this is your exposure on each of these sentences, especially in an open plea. Do you agree to that? Is that what you're taking a chance on?
And during the trial, during the post-conviction hearing, the state of Tennessee asked Mr. Ivey all of those types of questions. So I think and he confirmed that he was, if I recall the record correctly, and the record speaks for itself, that the court went through what that possible exposure was. And I quite frankly have to tell the court that I've been throughout East Tennessee and some in Middle Tennessee, and the plea agreements that are used by the 8th Judicial District and the one that's before the court now is probably one of the more thorough plea agreements that I've seen in 25 years. So, but I think that the record.
But the colloquy is extremely, back to Judge Ayers' point, the colloquy is extremely important, because if the judge said to Mr. Ivey, look, this is an open plea, and I can sentence you anywhere from X to 30 years at this percent to this percent because you're a career offender or whatever, and he says that to him and then says, do you understand that? Mr. Ivey says, yep, I understand that. Then there's not much we can do, one, but we don't even know, without that, we don't know if that happened or what happened, so there's nothing for us to review.
I disagree that there's nothing for the court to review, and as the court is aware that post-conviction hearings are adversarial proceedings, the state was well represented by counsel.
But it's not the state's burden of proof.
I agree with that, but if the defense is that the plea colloquy nixes this whole claim, the state of Tennessee could have presented that, same as the state of Tennessee could have presented Mr. Hurst to testify. So, presuming that the plea agreement was,
But it's not their burden.
I agree with that.
You have to prove your factual allegation by clear and convincing evidence. So you have to prove that he was not advised of this by clear and convincing evidence. If I'm the state, that means I don't have to do anything. You have to put that on, and if all you have is your client's testimony and you're not going to bring a plea colloquy or counsel to bolster that testimony, then how do you meet your burden?
Through the testimony of Mr. Hurst, through the allegations in the amended petition.
The allegation in the petition is no different than your client's testimony, so that's the same thing.
Right, but that's how we established it. I mean, if we established that what is alleged in the petition, we established that, and that supports a finding that Mr. Ivey's plea was not knowingly and voluntarily entered, same as in the Grindstaff case, same as in that particular case. And I'm not sure and we rely on Grindstaff in our case, but I'm not sure if the record in that case had a plea colloquy transcript either. He was misinformed. He was told that his trial counsel would seek probation when probation was statutorily ineligible, and he was told he would not receive a sentence of greater than 12 years. Based on those representations in 17-737, while he's got a bird in the hand 6-year sentence in 18-329 and 330, he entered his open plea in his 17-737, same as Grindstaff did in their case. And this court, I think the Supreme Court concluded that Mr. Grindstaff's he was misinformed as part of his plea because his open plea, he was statutorily ineligible for probation, but his counsel was telling that he was eligible for probation and he was going to ask for alternative sentencing. So I think that to analyze this case, the court does not need the transcript of the plea colloquy. The plea agreement's in the record, and the state has relied heavily on that in their response. But it's our position that the plea colloquy does not affect this court's consideration of whether Mr. Hurst was deficient in his advice or lack thereof, and whether, but for that deficiency, there's a reasonable probability that Mr. Ivey would have not entered this open plea, same as Mr. Grindstaff. So it's our position that the court does not need that plea colloquy transcript to determine the issue before this court. That's our position.
You're basically saying if everything was perfect in the guilty plea, as far as what was said about this, but the rub comes in before that when the lawyer told him something that he couldn't get or could get. And so that's where you're focusing your claim on.
That's correct, Your Honor. That's correct. I guess it's a two-step process. You got to go through what the plea agreement is, and then at that point, Mr. Ivey signs off on it, and then you go before the judge and do the plea colloquy. Assume that everything is properly correct in the plea colloquy. Nowhere in the plea colloquy would the court that I've ever been involved in would say, but now what has your lawyer told you? And what, it doesn't become into that kind of inquisition or that investigation by a trial court.
Isn't that because that's not relevant once the defendant enters a plea and understands what the potential sentences are? I mean, anything that was talked about before is really not relevant if on the day the defendant enters his plea, he understands the crimes to which he is pleading guilty. He understands in an open plea what the sentence exposure is for those convictions that he's agreeing to. I mean, that's what's in the record, that at that point that he agrees to all of those things and he knew what he was potentially exposed to.
And I would add to that, and in 18-329 and in 18-330, he was also told by Mr. Payne, and I think Mr. Hurst was part of that global agreement, the record will bear that out, that he would get 6 years on those two cases.
That's not before us.
But my point is that while Mr. Ivey is negotiating these cases, he's told in one case he's got a bird in the hand. He's told in this 17-737 that he's got a shot at no more than 12 years, but probation potentially. And so based on that induced him to sign this plea agreement, believing what his trial counsel that he had before, Mr. Hurst had represented him before, was telling him.
Right,
So
I think you're out of time. I think you've answered my question. So unless you want to keep using your rebuttal.
I'm showing a minute 42 unless it's been reset. But that's our position to the court. I'll defer to opposing counsel, but it's our position that that Mr. Mr. Hurst performed efficiently, and that but for that deficiency, there's a reasonable probability that Mr. Ivey would not have entered this open plea in 17-737. Thank you.
May it please the court, Catherine Redding on behalf of the state. I will admit to being a little bit confused about the exact issues that are preserved for this court's consideration. My read of the record suggests that the petitioner has waived his claim of ineffective assistance of counsel by raising it for the first time on appeal. As I read the post-conviction petition, I understand he is asserting in that petition that counsel was ineffective for failing to tell him that his charges exposed him to 30 years to serve. As I read the brief, I understand him to be arguing that counsel was ineffective for failing to discover that he qualified as a career offender for the Class D felonies and a persistent offender for the Class C. That to the extent that those are, to the extent I am understanding the briefs correctly and the petition correctly, that means that the discovery claim is waived on appeal. But the defendant is not entitled to relief regardless of this waiver because he hasn't established deficiency. And to the extent we're talking about post-conviction trial counsel's failure to discover that he was a career and a persistent for certain of his conviction offenses, he did not call plea counsel at the post-conviction hearing to ask counsel what he investigated. He didn't offer any of his own testimony on this topic, and even if counsel did fail to investigate or discover, as I understand the brief, the petitioner can't show that this failure caused counsel's representation to be deficient when there is a document in the technical record. It's a letter from the state. It indicates that the petitioner is at least going to be a range 3 offender.
Well, so despite your confusion of what issue, let me ask it this way. What issue do you think would be proper before us based on the record?
I think the issue that's raised in the post-conviction claim is waived because it's not briefed. I think the issue in the brief is waived because it wasn't raised.
Well, that's what I'm saying.
So I don't think any.
No, I didn't ask that correctly. I guess I'm not saying you're not saying they're waived, but like, which one was set up in the petition / the hearing that you would think would be properly before us? Does that make sense?
Like, which one was litigated below?
Yes.
I guess that counsel didn't. It's hard. I'm not trying to
No.
be tricky.
I presume we've got an order from a PC court saying, here's what I found.
We do, and the problem with the order, so the post-conviction petition has a bunch of allegations. That's my trial counsel told me this, my trial counsel told me this, and then the only thing, it's basically setting out facts, and then there's a sentence that says counsel failed to tell me that the court could sentence me to 30 years to serve. And then the post-conviction court just copies this paragraph. It doesn't say, petitioner has raised one claim of ineffective assistance of counsel. He says trial counsel never told him the sentences were going to run consecutively. It's not as clearly set out as that. So it is a little bit difficult to discern. But to the extent that he is claiming that we're not actually talking about, well, you didn't do enough research, which is not supported by any proof in the record. And we're actually talking about trial counsel's advice to me about my sentencing exposure was just wrong. The petitioners also waived that. And due to my confusion, it kind of comes in as an unknowing guilty plea. But I think that the facts and the argument in that section translate. I think those are responsive to a certain extent. Because we have I think the petitioner hasn't proven his claim that trial counsel just didn't tell me, that his advice to me about what I was receiving was incorrect, because we have only the petitioner's testimony. Obviously, it's going to be self-serving testimony because it's a petitioner testifying about what happened in his plea. We do have some testimony from the other attorney, but we don't have anything from trial counsel. Trial counsel was not presented. Trial counsel didn't say, yes, I told him, that's correct, that's what I told him. Or, yes, I told him 10 to 12 years, but I told him that it's going to run consecutive. We only have the testimony from the petitioner, and we don't have the plea transcript. So we don't know, and we don't know whether the trial court did, as trial courts generally do, and say, these are the charges, this is what you're indicted on, I understand you're pleading guilty here, this is your offender classification as this type of class range 3, you're exposed to this. Did you discuss this with your counsel? So we don't have the breakdown. We have the plea paperwork, and we have and the petitioner signed it, and he affirmed in that paperwork that he understood his charges, he had discussed his possible punishments with counsel, and he had reviewed the tables of punishments and parole release eligibility percentages. And the petitioner did admit at the hearing that he told the court he understood his sentencing exposure, that he was entering his pleas knowingly and voluntarily. So I think we have sworn testimony at a plea hearing that comes in via the petitioner's sworn testimony at a post-conviction hearing, and we don't have anything else. And I think the his sworn admissions in the immediate, right before he says, yes, this is what I understand, I want to plead guilty, I am pleading guilty voluntarily, I know what's going on. So we have that, and we have an admission from petitioner. And with that information, and without anything else, I don't think that the petitioner can prove his claim of deficiency. But I think his bigger problem, too, even if this court were to find that trial counsel, if the petitioner's testimony, 10 to 12 years, you can request probation. If that's true and that doesn't line up 12 years is not probation eligible. If the court were to find that counsel was deficient in some manner in conveying this information to the petitioner's second problem is that he has to prove, because he pled guilty, that he would have a reasonable probability that but for counsel's errors, he would not have pleaded guilty and he would have insisted on going to trial. And the petitioner testified at the post-conviction hearing, well, what would you have done had you known? And the petitioner's own testimony was, if that he had known he was ineligible for probation, he would have tried to go back to the original plea offer. That is not insisting on going to trial. And then he says, had I known that the trial court was going to give me 30 years, had I known definitively that that was going to happen, I possibly would have gone to trial. Neither of those amount to, I would have rejected the plea offer, I would have insisted on my right to go to trial. And that's what a petitioner who has pled guilty has to show. So even if counsel was somehow deficient, the petitioner just has not shown prejudice as well. And that is kind of given the confusion, or at least my confusion, that is the petitioner's burden here to show prejudice in this manner, and his sworn testimony at the post-conviction hearing does not meet that burden. So if there are no further questions, the state asks this court to affirm the judgment of the
Is there any credibility finding by the court about what this petitioner had to say?
No, the court did not make any explicit credibility findings.
Theoretically,
Yes.
back to a point that my colleague, Judge Dyer, I think, was making, and maybe Judge Ayers, theoretically, if Mr. Ivey files this petition for post-conviction and alleges these reasons that he was inadequately represented in their constitutional issues, and he puts them all in his petition and gets called into court, and the burden's on him to prove by clear and convincing evidence, factual allegations. So he testified, because this is pretty unusual with, usually we have the lawyer who represented him, but he testifies, the petitioner testifies, and there's no entry of the plea, any other paperwork except his petition. And he just says, this is what happened. Theoretically, now, if the PC judge said, I believe every word you're saying here, and I think this amounts to a constitutional violation of your rights, and I'm going to grant post-conviction relief. Next case. I mean, is that possible? I mean, there's no requirement that anything else. I'm not saying that's what happened here. I'm just curious as to, this has brought up some, in my mind, okay, what are there certain things that we have to have in a post-conviction case every time in order to grant relief? It's a pretty heavy burden. Even if we have all those things, it's a pretty heavy burden on the petitioner every time. So what do you think?
I think it depends on the nature of the claims, right? So petitioners there are certain claims where a petitioner has to testify. And if the petitioner's claim was here, counsel was ineffective for not discovering something, you have to put on counsel to say, yeah, I didn't discover it, or no, I did discover it, or I didn't need to do any research. I don't think that this court has ever said that a petitioner is required to put on counsel. I think that there is actually a bit of a split. I think the majority of the cases suggest, and I will admit that I'm going off of memory, but my recollection is that most cases say a petitioner needs to is not required, but if trial counsel's testimony is needed, that it's the petitioner's burden. I do think that there might be one or a few cases that have said, well, state, you didn't put trial counsel on, so this is actually your problem. But I think that the majority of them say if counsel's testimony is needed, it's a petitioner's burden. And I think that given, if the claim is failed to discover, petitioners trial counsel's testimony, or plea counsel's testimony was necessary here. But I think going back to your question about whether there was a credibility determination, I think that there was no explicit credibility determination, but given that the post-conviction court was considering petitioner's testimony at the evidentiary hearing and then the plea paperwork, which is signed, I think that it could be understood that the court was making an implicit credibility determination. Like, I'm going to think your statement's closer in time, or your signed plea paperwork, and the fact that you have affirmed that you've reviewed all of these things, that is more credible than what you're saying here now, that you have received a sentence you're not pleased with. So I'd be happy to research it. My recollection is that.
No, I was just curious I don't think I've seen one quite like this before. It made me start wondering about it. So you don't.
I certainly do not recall. My office would have heard if a post-conviction court granted relief solely on a petitioner's testimony. So I don't know that has happened.
This PC court did not grant relief. I mean,
Correct.
Yeah, but
Yes.
I was just
But
thinking.
I don't know that there's any law that would prevent a court from doing that. But I think certainly here the issue is more that the petitioner has not met his burden, and certainly that he can't establish prejudice as we look at it through the lens of a guilty plea. So if there are no
Thank you,
further-
General.
Thank you.
Mr. Stone, rebuttal, sir.
Yes, Judge, thank you. Mr. Ivey testified that, as the state has correctly pointed out, that he would have tried to go back to that 10 at 35 naturally. I mean, who would accept 30 when you got 10 at 35? Makes no sense. And secondly, he testified that he possibly would have went to trial. That's what the transcript will bear out. Just to respond to some of the things that the state had said, what was litigated below, and I went back and counted these, and I'll say them for the record. There are 7 references in the 71-page transcript to a knowing and voluntary guilty plea. Some of those references were by myself, and some of those were by the state's attorney. So clearly the issue, to address I think Judge Dyer's question, was what was the issue that was actually litigated in the court. And what was litigated in the post-conviction court was the issue that he was given bad advice on 2 fronts. The state is telling this, and that's that he would get no more than 12 years, and that Mr. Hurst was going to ask for probation. The elephant in the room on this case is the 30-year sentence that he got. How did the court get there? So even in the
So the question you pose is the reason that there's a problem. We have no idea what happened at the plea hearing. And without that, how can we address any of this? I mean, assuming that counsel did say, hey, I think you can get 10 to 12 and maybe probation, and then they go to the plea hearing, we don't know whether the trial court said, as General pointed out, here's what you're charged with, here's what you're pleading to, here's your exposure, here are your ranges. Did your attorney explain that to you? And if your client said, yep, he explained all that to me, I know exactly what we're doing, then you have a problem. But without that document, without that record, we can't really review any of this.
I disagree respectfully, and here's why. Echoing Judge Wiedemeyer's question about, are there certain things this court has to have in determining this issue? And there's nothing out there that says this court has to have
But a trial court at the end of a plea hearing at a plea colloquy, should make a finding that I find or don't find that this individual is entering their plea knowing and voluntarily. And that's what you're asking us to review. And so you're asking us to review whether it's a knowing or voluntary plea without knowing that what the trial court did and how the trial court acted. How can we determine whether it's a knowing and voluntary plea?
perhaps I'll sound circular in this, but that's not the issue of deficiencies within the plea colloquy are not before this court. And as Judge Wiedemeyer asked in my opening argument, it's the issues that occurred leading up to that induced Mr. Ivey to enter that plea agreement. That's the issue in this case. And with exception, I do believe that 18-329 and 18-330, the agreed sentence of that 6 years, while at a time he's going to an open plea like Grindstaff did, does create a little bit of confusion in his part that, oh, well, Mr. Payne, I've got 6 years on this at 30% range 1, but my attorney on 17-737 is telling me this. I don't like to be the lawyer on a case where new law comes out, and I'm hopeful that I'm not the lawyer on this case when new law comes out. But there is nothing that says that there has to be a plea colloquy. And now going back to Judge Wiedemeyer's question, the record is before this court of what was said. And I do believe that the trial court could have done what Judge Wiedemeyer said. Based on this testimony, this is the evidence before me. State you could have called Mr. Hurst, stop complaining about Mr. Stone, not calling Mr. Hurst, stop complaining about us not having a plea colloquy. You could have done all that. This is an adversarial proceeding. Mr. Stone's presented his case. There's clear and convincing evidence. Post-conviction granted, he gets a new trial. And that's what we're asking this court to do. Thank you.
All right, thank you, Mr. Stone. In general, we'll take it under advisement. Got one more case, I believe. Mr. Stone, you're on the next one too, aren't you? Mr. Clerk, call the next case, please.
Yes, sir.